all the monies collected by the property owner of Garden Green Apartments in North Hollywood, California, from both me and my parents from November 2007 through September 2013 were illegally obtained and resulted in roughly a $50,000 theft. For 7 months following my discovery of this theft, I'd been subjected not only to the abuses, attacks, and crimes of the property owner of these apartments and his thug management companies, Pacific Sun Management and Moss & Company, but I was also abused by people who are paid so Predonomic Society can function, legal and government agents. I've been subjected to the criminal refusal of any government agent to lawfully respond to the crimes committed against me and my parents by that landlord. Remember, I was very ill during all of this. The constant dizziness, nausea, and headaches that I spoke of in my previous Medicare video segments did not go away while all of this was happening, despite my having evidence of possible tax fraud and the committed crimes of welfare fraud, criminal harassment, fraud, theft, extortion, and extortion across state lines committed by this landlord. No government agent or lawyer I contacted gave one damn. You see, no matter what, the property owner is the responsible party here. He's legally responsible for the actions taken by his employees on his behalf. And he's the one who profited by the breach of contract, fraud, theft, and extortion committed against me and my parents. He's the legal responsible party. The response to my eviction court summons that I filed with the court included a change of venue demand. Like many other jurisdictions in the United States, LA County is illegally shutting down access to the government. They're even illegally shutting down courts throughout the county, making access to the courts an extreme hardship, if not an impossibility, for many of the Comlin. Although there was a court building just 35 minutes away using public transit, my eviction case was moved to Santa Monica, one of the most fascist cities in America, which was over a 3-hour public transit ride just to get to court. The lady at the Santa Monica court who handled these changes of venue got sick, and no one was assigned her duties while she was away. I called nearly every day to check on my status, but my change of venue was not officially put through until an hour before I was in front of a judge. The stress involved in this obscene process was excruciating, but I got the venue changed to downtown LA, which was 2 hours away by public transit. The eviction court bailiff was nothing but a little thug who treated all us victims of eviction like criminals while he chummed it up with the attorneys of the various landlords. Even though I told him the Santa Monica court told me to come there, he tried to deny my change of venue. My case was assigned to Elizabeth Pfeffer, a judge who wasn't normally an eviction court judge, and this may have been what saved me, to a point. The property owner nor Moss & Company managers didn't even appear in court, and no one from Pacific Sun Management appeared. No one involved in this case was present except me. By law, the accuser, the property owner in this case, must appear in court for his own court cases. I don't know. But I guess in fascist America, the accused no longer have the right to face their accusers, or even know who they are. Their lawyer knew my defense through the 8 letters I sent to Moss and Company and the evidence I shared with them. How was this lawyer planning to defend against my defense with no witnesses or documentation to support his position? He obviously had no defense, and the judge let him get away with it. I sent all my evidence and documents, along with my handwritten, detailed 15-page response to the court. I presented my case the best I could, considering how sick I was. I proved not only a breach of contract occurred, but also extortion across state lines, fraud, and theft. I reviewed all the details of the crimes committed against me and my parents in court with Judge Pfeffer. Despite the opposing lawyer's objections, the judge allowed all the proof into evidence, including my parents' affidavit, saying it might turn out to be too important to leave out. But I wasn't allowed to present my full case, not allowed to show the evidence of the 7 months of harassment, intimidation, and retaliation Moss and Company committed against me. And the judge didn't care to hear how Moss and Company was denying me my right to property owner contact information and refused to make the lawyer divulge it to me. I was, however, able to present a secondary defense. The pay or quit notices were all screwed up. The total of what they claimed was correct, but it was misrepresented on the notices in their depiction of what was owed per month and why. The way it was presented, they didn't credit me for the rent I paid. They were a mess. They really didn't make any sense. The lawyer defended the notices, and the judge spent most of the court time admonishing him at the end of the court session. Judge Pfeffer found in my favor, but a week later, after receiving her written conclusions, I discovered she did so based entirely upon my secondary defense, the incorrect notices, and not my proven primary defenses of breach of contract for the non-delivery of the rent increase notice, overpayment of rent, extortion, fraud, bank fraud, and money laundering. I didn't expect the judge to follow the law at all. But if I won, I did expect the court to order the return of the roughly $50,000 overpayment of rent, and the court-ordered police investigation into the allegations of fraud, theft, extortion, bank fraud, and money laundering. But what I got was nothing. Pfeffer was just another in a long line of government agents who refused to correctly enforce the law. She could have based her findings on both the incorrectly filled out notices and the breach of contract, or on the breach of contract alone. But she chose to incorrectly find in my favor based only on the inaccurate pay or quit notices. This decision did nothing but continue to make me vulnerable to the landlord's further attacks and predation. The very next day, following my court victory, a week before the judge mailed her official findings, Moss and Company issued to me yet another, a fourth, 3-day pay or quit notice concerning the very same issues they couldn't prove in court the first time. By ignoring the breach of contract, the illegal rent increase. The judge gave my abusers license to continue their attacks on me and merely instructed them on how to be more successful the next time. I notified the judge in writing, asking her why she denied me any monetary damages even after I proved fraud, extortion, and breach of contract in court, and the letter was completely ignored. I guess in the United States, the elite can continue to sue over the same issues until they can get a judge that supports their lawsuit and finds in their favor. You see, the Fifth Amendment, which protects us from double jeopardy, doesn't apply only to the government. By law, no one, not even the elite, is supposed to be able to abuse the court system for purposes of harassment, retribution, or predation. You can't just file lawsuit after lawsuit over the same issues until you get a judgment in your favor, or to force the accused into submission or an out-of-court settlement. But this is exactly what Judge Pfeffer allowed my false accusers to do. Contracts and laws don't apply to the elite unless they benefit the elite. This means we have no law in this country. We live in a lawless society. It's called predonomics. But wait, this story's not over. There's still more, and I'll continue with this segment on the selective enforcement of the law in the next video called Equalism 110D. Please share this video series with as many equalists, non-predators, as you can. Thanks.